Welcome back to the second segment of this law session of English legal system dealing with the criminal justice process. Now, within the criminal justice system, of course, just before the break, we were looking at the two models under the system, or the two models according to Packer, of course. There are other models, but by and large, as under the syllabus, these are the two which will become important for you. I would certainly encourage you to look at others, which I'll mention later on, but these are the predominant ones. And I flagged up that there is, of course, the crime control model, and I gave you a brief example, and of course I also raised the due process model. Now, let's return to the crime control model, because the idea of the crime control model of our criminal justice system is that there are certain assertions and concerns on which it rests. And they are these. The first is that the repression of crime should be the most important function of criminal justice because order is a necessary condition for a free society. So the idea is crime should be repressed at all costs. The criminal justice system should concentrate on vindicating victims' rights rather than protecting offenders' rights. Now, it also goes on to say police powers should be expanded to make it easier for them to investigate, arrest, search, seize, and convict. The point I want you to, of course, pick up on is when you look at these bases that the crime control models stand on, what about them make you feel uncomfortable, if at all? I know somebody might say, well, a rapist, he should be hung, drawn, and quartered. But the fact is, you have to always consider, what if the person is innocent? But then we'll leave that for the due process model. But the idea is, crime control is all about that, controlling crime. So police should have expanded powers to make it easy for them. Next, it says, when you look at legal technicalities, they should, of course, be eliminated. So legal technicalities, which, of course, appear to handcuff the police themselves, should be eliminated. So go back, for example, as I mentioned before, the O.J. Simpson criminal trial. We do see that there was a technicality with this glove, and also the fact that there was this issue about the contamination of evidence. So the idea is, when you look at technicalities as the criminal as the crime control model calls it, these tend to be issues with evidence and how the state actors have operated. Now, the criminal justice process, it says also, should operate like an assembly line conveyor belt, moving cases swiftly, moving them along towards their disposition. Also, it says if the police make an arrest and a prosecutor files criminal charges, the accused should be presumed guilty because the fact-finding of the police and the prosecutors is highly reliable. Now, if we look at the miscarriages of justice, then what I'm saying to you is, that is how you get yourselves into problems when you go from the standpoint of a crime control approach. Now, the main objective, it says also, we're still under the crime control model, and what it considers are the main bases on which it stands. The main objective of the criminal justice process, it says, should be to discover the truth or to establish the factual guilt of the accused. So when you look at what the crime control model is about, it really is about pushing to reduce crime at all costs, giving more powers to the state actors, setting out a presumption of guilt, and more or less ensuring that we are supposed to be in a safer society. That said, let's contrast it with what the due process model requires, or the framework on which it rests. Due process looks at process being due, going through the right procedures then. And it is the principle that the government must respect all of the legal rights that are owed to a person according to the law. Now, it holds the government subservient to the law of the land. And when I talk about the government, I mean state actors like the police as well. So it holds the government subservient to the law of the land. It protects individual persons from the state and is frequently interpreted as placing limitations on laws and legal proceedings in order for judges instead of legislatures to define and guarantee fundamental fairness, justice, and liberty. Now, the whole idea of due process bears some analogy to natural justice and procedural justice, because it also says that the government should be fair to the people. Now, Packer's due process model is a counter-proposal to the crime control model, and the due process model, of course, consists of various arguments. It says the most important function of the criminal justice process should be to provide due process or fundamental fairness under the law. That's due process. You have fundamental fairness as it relates to how you're dealt with. It also says that the criminal justice should concentrate on defendants' rights, not victims' rights, because the Bill of Rights expressly provides for the protection of defendants' rights. Now, of course, he's writing in the American context, so please bear that in mind. Police powers, he said, should be limited to prevent official oppression of individuals. Constitutional rights aren't mere technicalities. Criminal justice authorities should be held accountable to rules, procedures, and guidelines to ensure fairness and consistency in the justice process. Again, go back to the OJ trial. It's saying, don't imagine, oh, well, then it's just a technicality. Because if it's a technicality in one defendant's case, what might be the technicality in yours if you were, for example, have to avail yourself to the criminal justice process? It also continues under the due process model that the criminal justice process should look like an obstacle course consisting of a series of impediments that take the form of procedural safeguards, and those procedural safeguards serve as much to protect the factually innocent as to convict the factually guilty. It also continues and says the government shouldn't hold a person guilty solely on the basis of facts. A person should be found guilty only if the government follows legal procedures within the whole fact-finding process. So when you look at the due process model, it really is about fairness, looking at fundamental rights, and holding the government and the actors of the state accountable. Now, as I say, there are other models which I would suggest you take a brief look at, make your notes about them, but certainly they are simply there for you to draw on by way of analogy more than anything else. These, of course, include the medical model, the restorative justice model, the bureaucratic model, status passage model, power model, social integration and exclusion models. Again, minor players, but nonetheless, for you, I would suggest you make some notes on them briefly. Now, there appear to be three stages of the criminal justice process. The first is to investigate, so the investigation process. The second is the trial, and the third, of course, is the appeal. So when you look at the criminal justice process, the idea is that each of these ought to be beyond reproach. Now we see that the police tends to be involved at the investigative stage. We see that the prosecution service and the judges at the trial stage, and certainly the courts again and the judges at the appellate stage. When we look at those three stages, they tend to be there as a kind of check and balance when you look at this concept of the miscarriage of justice. Now, I said at the beginning of the previous session that we would look at predominantly the models which we have, and certainly, as I say, you need to look at the advantages and disadvantages of the two models, and you should also see whether is it realistic to have a society where it goes down the path solely of crime control or solely of due process. Is it too far, too wide apart, and are they both too far at the other end of the spectrum, or is it that most societies display some points from each? So that is what you need to consider in the context of, for example, the models. what I want to move you on to, of course, is miscarriage of justice. And as I've flagged up already, when you're looking at the whole idea of the process, it is about investigating, then the trial, then the appeal. It is there as a check and balance. What then is miscarriage of justice? What does it mean? What is it that we're trying to protect when we say that there must be effective investigation with an effective trial, with the appeal process there to oversee it? Well, it doesn't just mean wrongful convictions or unjust sentencing. It does have a broader meaning. So, for example, police misconduct, failure to protect the rights of victims of crimes, the remedies for wrongful conviction, for example. What is it that a defendant can avail himself to? So the idea of a miscarriage of justice is that when you look at the process, has there been somewhere along the continuum that there has been a breach in the investigative or the trial process, or indeed the appeal process? When we look, for example, at the remedies for wrongful conviction, you can, of course, have an appeal from the magistrate's court. Now, there are three routes of the appeal: to the Crown Court, to the High Court by way of case stated, also to the High Court by virtue of judicial review. You can have an appeal to the Crown Court against convictions. Now, this is usually alleged that the convicted person has been convicted against the weight of the evidence. Currently, though, it takes the form of a complete rehearing when you're doing that sort of appeal. Now, the grounds for appealing are unrestricted and fresh evidence is allowed. Although few defendants appeal, the success rate of those who do is actually quite high. So what we're talking about here is persons going from the magistrate's court and appealing. About 33% of persons who appeal tend to be successful. That is a worrying figure because it suggests concern about the quality of summary justice, meaning justice within the magistrate's courts. There are limitations, however, when we look, for example, at these appeals. The appeal must commence within 21 days of conviction. Public funding for representation at appeals is means and merits tested, so you don't automatically get help. Defendants do risk a longer sentence when they're appealing. Now, this whole area of looking at the criminal justice process has been considered, and certainly the one report that I want to refer to at this point is the All report from Lord Justice Hall, where he did make some recommendations in his report. And one of the things he recommended was that appeals from magistrates' courts shouldn't take the form of a rehearing, and that there should only be one route of appeal, to the Crown Court, and that you would need leave for that. He also said that the grounds for appeal should be the same as the restricted grounds for appealing from the Crown Court to the Court of Appeal. Now, when you look at what was said, there has been a critique by Mallison, and this is set out in the Criminal Law Review in 2002 at page 272 to 282. And Mallison said that the argument for a single route of appeal was well-founded, but the removal of the automatic right to a rehearing was not. So when you look at the magistrate's court to the Crown Court, arguably, we see what Lord Justice Hall has put forward, but Mallison does appear to make a valid point given this sort of high success rate based on the appeal, and given that it is because of this automatic right to have a hearing that may have given rise to this. So yes, looking at it as being well-funded, because at the moment you have an automatic right, should that be curtailed somewhat? So that, of course, is the appellate process when you're going from the magistrate's court to the High Court or the Crown Court. What I want us next to consider is an appeal from the Crown Court. I'm going to take a short break at this juncture, and as soon as we return, we will carry on by looking at how the appellate process works in order to at least ensure that there's transparency and to try and limit miscarriages of justice.